Good morning to all of you. Welcome to Legal Matters by Srivastava Sunkara. In this video, we are going to discuss a case law on anticipatory bail where the condition precedent was that the accused has to take a DD for 10 lakhs towards add interim compensation to the wife victim. But it is held unreasonable, unwanted by the Honorable Supreme Court of India. So the case is Ravikant Srivastava versus State of Jharkhand and another in Criminal Appeal number 1803 by 2022, decided on 18/10/2022 by two judges bench. So Honorable Justice Ajay Rastogi and C.T. Ravikumar of the Supreme Court of India held that there is no reasonable justification for the High Court of Jharkhand to direct the appellant, that is the person seeking anticipatory bail, to deposit 10 lakhs in the name of his wife for granting anticipatory bail. This is what is held by the Honorable Court. Actually, you all know that this is a matrimonial dispute between wife and husband. Actually, the marriage was solemnized on 11/6/2015 as per the Hindu rites and customs. Of course, slowly differences cropped up. Due to the differences, actually the appellant, that is Ravikant Srivastava, he filed a case of nullifying the marriage. So he wanted to go for the nullification of the marriage. He filed a petition for divorce under section 13 of the Hindu Marriage Act. He filed the dissolution of marriage petition on 8/7/2016. After all, 1 year only, they could live well. As a counterblast, the wife, she filed a case of harassment, that is 498A, 120B, 323, 324, IPC, read with section 3 and 4 of the Dowry Prohibition Act. These sections you all know, I need not reiterate. Simply to say it is a case of harassment for additional dowry. So because she has given the case FIR against the husband and others, 120B is also added. So this was registered as crime number 3055 by 2018 on 12/2/2018 in Jharkhand. Right. So since the case was registered against him, and actually please remember, this is a private case, she filed a private case. The magistrate under section 156 clause 3 CRPC has forwarded it to the police, and the police have filed the charge sheet. They are about to file the charge sheet. Anyway, the matter is under investigation. So the appellant, that is Ravikant Srivastava, he apprehended arrest by the court or by the police. Therefore, he approached the Honorable High Court of Jharkhand for pre-arrest bail or anticipatory bail. So, as per section 438 CRPC, you all know that if a person is apprehended, arrest in the hands of police, then he can go for the so-called anticipatory bail or pre-arrest bail. So, where if the court is satisfied, yes, they can direct that in case of arrest of the person, he has to be released on bail. You all know, according to 437 CRPC, police cannot give bail in a non-bailable offence. So please remember, anticipatory bail applies to non-bailable cases. This you know very well. I need not reiterate time and again. Here, the High Court granted bail, granted anticipatory bail, but the condition precedent is that he has to deposit 10 lakhs as add interim victim compensation to the victim. So this was done on 5/3/2021. Actually, the High Court used its powers under section 482 CRPC, we can say, in order to do complete justice. But aggrieved by this, the appellant, that is Ravikant Srivastava, he approached the Honorable Supreme Court of India. Supreme Court of India held there is no justification in asking or in directing the appellant to deposit the money. It's not correct. If you want to give bail, basing on the facts and circumstances, grant the bail. Put the conditions. We all know that he has to cooperate with the investigation. He should not leave India. He has to surrender the passport to the nearest police station. He should not induce the witnesses. He should not threaten the witnesses. All these conditions. Or he should visit the police station daily at so and so. These conditions will be there. But not 10 lakhs deposit. This is a peculiar incident. So which is held unreasonable, unjustifiable. Ultimately, the orders of the High Court have been dismissed. The appeal is allowed. Of course, the bail is granted to him. So, very good judgment, very simple point. No doubt, High Court using its inherent powers has granted victim compensation. But it is not correct in the view of the Supreme Court. Very good judgment. Please read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.